Most parents don't realize this until it's too late. The biggest danger in a CPS case isn't always the allegations. It's assuming your court-appointed lawyer will fix everything automatically. They won't. And that's not because they don't care, it's because of how the system is built. Court-appointed lawyers operate under severe constraints, time, caseloads, and procedural limits that most parents never see. Understanding what those lawyers cannot fix is often the difference between saving a case and watching it quietly unravel. The first mistake court-appointed lawyers rarely fix is early damage. By the time an attorney is assigned, the record already exists. Statements have been made, reports have been written, safety plans have been signed, admissions, intentional or not, are already in the file. Court-appointed lawyers don't rewind the tape. They step into a moving train, and most of their work is reactive, not corrective. If something damaging happened before counsel got involved, it often stays in the record forever, unless aggressively challenged, and many appointed lawyers simply don't have the bandwidth to relitigate early errors. The second mistake they rarely fix is bad documentation. CPS cases live and die on paperwork. If a social worker's report is vague, conclusory, or inaccurate, that should be challenged early and often. But court-appointed lawyers frequently rely on what's written rather than rebuilding the record. If something isn't documented properly, missed visits, incomplete services, inaccurate summaries, those gaps don't fix themselves. Silence becomes acceptance, and once a narrative solidifies, it's very hard to undo. The third mistake is missed strategic timing. Dependency court runs on deadlines, stages, and statutory windows. Certain arguments only work at certain points in the case. Court-appointed lawyers are often focused on the hearing in front of them, not the consequences 2 hearings down the road. That's how parents wake up at a 366.26 hearing, wondering how they got there. Not because nobody objected, but because nobody planned. The fourth mistake court-appointed lawyers rarely fix is client passivity. Many parents believe their job is to sit quietly and be cooperative. They assume their lawyer will speak when it matters. But dependency cases reward proactive behavior. Judges notice parents who document, clarify, ask questions, and follow up. Court-appointed lawyers often don't have time to coach clients on courtroom posture, language, or strategy, so parents unintentionally hurt their own case by staying silent when clarification was necessary or speaking emotionally when precision was required. The fifth mistake is failure to build appellate-safe records. Most parents don't think about appeals until it's too late, but every CPS case should be built with the record in mind. Court-appointed lawyers may object, but they don't always frame objections in a way that preserves future challenges. They may argue fairness instead of statutory error. Judges don't reverse themselves based on emotion. Appellate courts don't either. If the legal issue isn't clearly preserved, the mistake becomes permanent. Another mistake that rarely gets fixed is assuming services equal protection. Completing services feels productive. It feels safe. But services alone don't prevent removal or termination. What matters is how those services are documented, interpreted, and connected to safety. Court-appointed lawyers often assume compliance speaks for itself. It doesn't. Compliance without narrative is just paperwork, and paperwork without strategy is dangerous. Finally, court-appointed lawyers rarely fix false confidence. Parents are told, "You're doing great," right up until the case takes a sharp turn. That's not cruelty, it's systemic reality. The lawyer may believe things are fine based on limited contact, while the case record quietly shifts against the parent. By the time anyone realizes something is wrong, the legal options have narrowed. So here's the truth: no one tells parents early enough. Court-appointed lawyers are essential, but they are not strategists, they are not investigators, and they are not responsible for fixing every mistake that occurs in your case. That responsibility often falls on the parent. The parents who survive CPS cases are not the ones who rely blindly on the system. They are the ones who understand it. They document, they ask, they prepare, and when necessary, they intervene strategically before the damage becomes irreversible. If you're currently in a CPS case, or if you feel like your case is drifting in a direction you don't understand, this is the moment to pause and reassess, because waiting rarely fixes anything in dependency court. I am taking a very limited number of emergency CPS cases for strategic intervention only. This closes soon.